I'm Michael Spence. I'm the President of Provost of UCL, and I've just returned to this country to take up this role at the start of this year. So it's a great joy to me as an IP lawyer to be able to participate in this terrific event to celebrate both Sir Robin Jacobs' 80th birthday and, of course, World IP Day. Well, who else but Sir Robin could have managed that feat? I'm informed that when he was a barrister, Sir Robin had almost supernatural powers to put his hand on just the most relevant documents, and that they'd mysteriously float to the top of vast chaos of paper, saving him the bother of reading the rest. And of course, everyone marvels at his age-defying abilities. So for someone with those kinds of abilities, it was doubtless a trivial effort mysteriously to arrange for World IP Day to fall squarely on his birthday. But we are in any event all very grateful for the superhuman engagement, energy, and ability that he's brought to this field, and in recent years to us at UCL. Sir Robin's family has a long association with UCL. His father, Sir Jack Jacob, was one of the leading academics in the field of civil procedure, and several of his relations attended UCL. Well, of course, the UCL law faculty is by any measure extraordinary, but particularly amongst others in the field of intellectual property. It really has become one of the leading centres of intellectual property education, with a very successful undergraduate, graduate and postgraduate IP programs, as well, of course, as a suite of professional courses. In a typical year, around 100 undergraduate and postgraduate students study IP at the Faculty of Laws as a part of their degree. And IBIL, the faculty's IP Centre, is a real hive of activity. It was established by Sir Hugh Laddie in 2007. IBIL benefits from a unique blend of academic, practitioner and judicial involvement, and is really well supported by numerous sponsors amongst firms and chambers and other institutions. We're incredibly grateful that you've kept up your support even during the pandemic. This funding not only enables IBIL to run its characteristically lively program of seminars, lectures, debates, and conferences, but also supports original IP research and funds students' research scholarships. We still mourn the passing of Sir Hugh Laddie, the very untimely passing of Sir Hugh Laddie, but the chair named after him at UCL could not have been better filled than by Sir Robin, one of Hugh's long-term colleagues as a practitioner and judge in the field of intellectual property, with whom he had a very special fraternal relationship and probably also just a bit of a gentle rivalry in their chambers. Sir Robin himself, of course, has made an outstanding contribution to the law as a barrister, as a judge, as an academic, and as an international leader in the field of IP. He's one of those rare lawyers who has both what Lord Mansfield called incredible situation sense, an ability pragmatically to see to the heart of a practical issue and to solve it, but also a capacity for a high theory and an ability to bring the two together in a way that makes the law make sense, or at least more sense than it did before he started grappling with it. So to celebrate Sir Robin's 80th birthday, our IP Centre, in association with his former chambers, 8 New Square, have arranged this seminar in his honour. And I'm just very grateful to them and to UCL staff for doing so, and to so many of you for attending. I'll now hand over to Dr. Ilana Fima, co-director of IBIL, whom most of you know well, to chair the seminar. And may I say, Sir Robin, on behalf of all of us here at UCL, happy birthday, and thank you for the extraordinary contribution not only that you have made, but are continuing to make.
Thank you, Michael.
Thank you, President and Provost. Let me in turn pass over to Daniel Alexander QC, Head of Chambers at 8 New Square, who will be speaking with Robin about his life in intellectual property, at the bar, on the bench and in academia. Daniel.
Thank you very much, Ilana. Thank you very much, Michael, for that fabulous introduction, and welcome back to England as well. And I might say welcome back a little bit to the field of IP. I know that you were a great academic in this field as well. So I'm a former and now again colleague of Robin's at 8 New Square, and also involved with IBIL. And we thought it would be fun here to do this little seminar to celebrate Robin's birthday. And it's a tribute to his generosity and engagement in the field that he's actually been prepared to do an academic seminar on his 80th birthday. So Let me start with asking you a few questions, Robin, about your father, who Michael mentioned, who had a long association with UCL and was one of the great academics in the field of civil procedure. Tell us a little bit about him and his influence on your work as a lawyer.
Well, my dad came to this country as an economic migrant from Shanghai, coming from a Iraqi Sephardic Jewish family, but he went to something like a grammar school in Shanghai called the Shanghai Public School for Boys. And on one occasion, the man who became the headmaster, Mr. Bennett, wrote in his school report, would do well at any English university. And that was read out to my grandmother, who couldn't read. She'd been married at 15. My dad was number 3 at 18. She could play cards, she could play mahjong, but she couldn't read, but it was read out. And she got into her head that my dad might go to London. Number 1 son wasn't allowed to go because he was number 1 son. Number 2 son wasn't trusted to be a good Jewish boy, so he couldn't go. And he was bitter about that. He didn't even see my father off. They made friends years and years later. And so number 3 boy, who was trusted to be a good Jewish boy, he got it. And the other 7 children stayed in Shanghai. And he came to UC. He went to LSE first. It didn't really matter which university in London you're at, because it was all one single degree, University of London degree. And he was taught by Eli Lauterpacht and so on. He got a scholarship to UCL. And he loved it all ever since. And that's why he went back when he was a master and invented the course on civil procedure. Well, that's the story, really. I've got others, but I don't think there's enough.
I read something about him, Robin, where he was described as helping to bridge the gap between academic and professional worlds. Like father, like son?
Well, a bit of that. I mean, I was described as an academic by the provost. I can remember the Court of Appeals and Peter Oliver saying, "Mr. Jacob, isn't that a bit academic, my lord?" I said, "My lord, I've never been called an academic." Yeah, you see, some subjects, I think IP is one, is very difficult to do in the abstract, because a lot of it is about how it works. I mean, I've realized that, you know, I come to UCL and I thought, well, you have validity, you have infringement, and that's what IP is about, and you have cases about it. And I missed out on that. It's only Mark Anderson who came and volunteered almost the first thing my announcements were made to come and do transactional law that made me realize that actually IP law is a 3-legged stool. It will fall over with only 2. And transactional law is maybe the most important branch in the real world. It's how it works.
So another thing that was said about your father was that he took an approach to decision making that was based on the court playing a passive, non-interventionist role. Like father, like son?
I don't think that's true of my dad at all.
Right.
He understood that was the function of the court, and it's one of the hardest things being a judge is not to step off the bench, but to just lean over a little bit from time to time. I mean, you should, if you can, cause a case to settle, but you mustn't bully people into settlement.
So how did you come to be an IP at all?
Well, it's quite simple, really. I never wanted to do law at all. My dad did law. He told me 1 or 2 stories that made me sort of understand law. He did a lot of work in the schmutter trade. And he said that when prices go up, people who are selling fabric want to get out of the contract because they want to sell at a higher price to somebody else. And if prices go down, the other way around. And suddenly that sort of, it nestled in my head. I suppose he told me when I was about 10 or 12. And it didn't seem, it suddenly tells you about how it works. And I learned a lot from him. I learned a lot from the way he talked with his great friend Louis Blom Cooper. Louis, he was his pupil. I met Louis when I was 14, and they used to argue like hell about all sorts of things I didn't really understand. But whatever it was, they were having huge fun. So when I was at Cambridge, and it was quite clear this brilliant career of a Nobel Prize-winning physicist was not lying in my way, and I had quite a lot of friends who were lawyers, I thought, well, I might have a go at this thing here. And if it all fails, I'll go to this thing called the patent bar. Now, I knew about the patent bar because in the ancient times, parents took their children to the theatre. And we always used to go to the Old Vic. And on one day, we were going to the Old Vic, and I'd gone during the day up in a two-seater Tiger Moth with a friend of mine, and back to his house in Balham, and then back up to see my dad, who was quite a new Queen's Bench master. And he said, well, I've got to go to this party before we go over to the Old Vic. Just go and stand in the corner. So I did stand in the corner. And all the great and the good of the law were at that party. Denning, Hailsham, all Court of Appeal, much smaller Court of Appeal. And I got talking to this little bloke in the corner, and he said, what are you doing? I said, I'm going to Cambridge. What are you going to read? I said, natural science. He said, when you come down, come and see me. Go to the patent bar. And that put the idea in my head. So when I decided to go to law, I said, I'm not going to do that. I'm just going to be a regular lawyer. And in the way of things, my dad rang up the Treasury Junior and said, will you have my son as a pupil? And he said, yes. So
very different times.
How
people got into things.
Well, there's a bit of that with you, Daniel. I mean, we got you into Chambers because I met you in the street after you turned us down and said you really should come to us.
Yes, and you were a very persuasive advocate.
Well, it wasn't difficult. You said, well, I'm going to Fountain Court. They do competition law, and you're interested. I said, well, let me tell you two things about competition law. Firstly, it's not nearly as interesting, or European law. I think it was general European. It's not nearly as interesting as you think it's going to be, as it ought to be. And secondly, we actually do a bit of competition law in Chambers. And you said, can I do a mini pupillage? And I said, yes. So much for Chambers committees. When, you said? I said, tomorrow. And there you were, with me leading David.
So the thing that sticks in my mind was that you said, you don't want to go to where you were going. Come here because you will have much more fun. So what do you what do you say about the importance of fun in law in your life?
I think it's absolutely vital. I mean, if you sit there greyly doing nothing, I'm not know how people do it. I once complained to Simon Thorley in court. I said, Mr. Thorley, it's 3 o'clock and we hadn't had a joke all afternoon. And it just came out. Of course, that was a joke.
So when you joined Chambers as a junior barrister, what was it like at the time for you? Was there a lot of work? Was it stressful? Was it fun right from the start?
I had 2 pupilages. Nigel Bridge hardly had time to talk to me. He was the Treasury Junior. And in those days, all government work except traffic accidents, mainly of the post office, which was part of the government then, were done by one junior. There was a Chancery Junior too. So he was really busy, and I saw a lot. I saw and saw and saw. I saw Conway and Rimmer in the Court of Appeal. I saw I saw Lord Reed in action quite a lot in the House of Lords. But I didn't, and I did one job for Nigel, which he said, this is very good, and I'll take it up for typing. I haven't forgotten that. It's a tiny point about settling a case to magistrates and to a magistrates court. When I came, I didn't even dare ask those chambers whether I could get in. They might have taken me out looking back on it. I didn't dare ask them. I was doing the second part of my law degree as an evening student at the LSE and getting married and doing a pupillage all at the same time. So it was a bit tight times. But when I then wrote off, I said, I'm going to go to the patent bar. And I wrote off to a chap in Chambers who said, I'm retiring. A whole lot of them retired because they're changing the tax rules in 1967. Write to somebody, it was in what is now 11 South Square, they wouldn't have me. He said, write back to somebody else in what was Francis Taylor Building, and that was Anthony Walton. And I was his first and only pupil. And suddenly I found myself in this tiny, tiny set with many more rooms than people. Looked as though it was falling apart, hadn't been painted for years, dust everywhere. And a bunch of geniuses in their different ways, 4 of them.
So you talk of the geniuses. There was another person you've often mentioned as a big influence, Tom Blanco White.
Yeah. He'd just become head of chambers. He hadn't got silk. There used to be fierce debates between him and Anthony, particularly at tea time. And you learnt from those. Most of the stuff I put in my judgments, I nicked from one or other of them.
And of course, there was another important influence who arrived shortly after. A certain...
Quite a bit after. I mean, Hugh Laddie.
Mr. Laddie.
Yes, a noisy little bugger.
Did you recruit him, by the way?
Hmm?
Did you recruit him?
No.
It wasn't you.
It was quite easy to get into chambers those days. Basically, you got into the chambers if you asked. There were no pupillage committees. You didn't actually go to chambers at all. You went to an individual. Said, can I be your pupil? That changed in my time in chambers, but it was still true. David Kitchen wrote to me. It happened my dad's time when he took all those women pupils. He had a lot of women pupils, my dad. 5 by 1956. The first one, he went to his head of chambers and said, I'm going to be taking a woman pupil. The head of chambers said, no. He said, yes, well, where would she go? Well, where will you go? Well, the clerks wouldn't like it. I've spoken to the clerks. Well, the other member of the chambers wouldn't like it. I've spoken to them. Cunning old sod, my dad. Then the head of chamber said, no, I don't think so. Dad said, well, I don't think it'd look good if it got into the papers that the head of the Bar Council wouldn't have a woman in his chambers.
Sounds very persuasive. So tell us a little bit about your relationship with Hugh.
We were mostly in parallel. We used to think we didn't really need to finish sentences because I knew what he was going to say and he knew what I was going to say in advance. Yes, there was rivalry, and that was all right. But actually, we hardly ever fought in court when we were barristers. What happened was I managed to pick up all this record company work. We're dealing with record pirates. And it just became overwhelming. And so Hugh picked it up too. And we used to go into the motions court and judges couldn't tell one from the other and say, yes, Mr. Laddie to me, or yes, Mr. Jacob to him. Because we were doing all these record companies, we were the guy who did the record companies. But really, it was a very, very, very productive relationship.
I'm getting questions from all around the world from people who are attending. And one of them we had was whether you had someone who you would identify as your biggest professional influence. Is there a single individual you'd mention, or are there too many to mention?
Well, there are many. I think overall it was Anthony Walton, my pupil most. I was influenced within chambers by Blanco. Cunrick Lewis was wisdom, and Julian, who was much more junior then, was just getting going because although he'd been called to the bar and was 10 years older than me, he never actually did much. He was editing wine and food and things until he married Deborah, and she said, you are now going to work. And so he did. But I think that so outside chambers, it was Tom Bingham. I did a few cases with Tom Bingham. I got him into the Columbia trademark. We did a couple of things before, and he paid me the greatest compliment of my legal life. He phoned me one day and said, would I be his junior in the House of Lords? A case called D and the NSPCC.
Wow. On significant cases, what would you say is your top pick from your bar practice?
Oh, I think it's got to be Norwich Pharmacal.
And why is that? I mean, you mentioned a case which is a case about procedure, really, or about getting information.
It was more about procedure. It was a procedural case, but it transformed, or part of the great transformations, perhaps the biggest single transformation of English civil procedure, when suddenly people got the idea, well, let's not say it can't be done, but start off by saying, well, let's think of things we can do. Anton Piller was a follow-on. I think the Raver was of the same time, and an attitude of we can do it, we can make it happen. That's why it was such a big case. It's impossible for anybody now to know what the world was like before Norwich.
I mean, one of the key things about a lot of these cases are that they're about getting more detail on the facts, what happened, who did what. How important do you see that in IP generally, on the balance of facts and law in actually making decisions?
Well, I mean, obviously, if you can it's nice if you can run and defend it as a shit case, or the plaintiff is a wicked, oppressive bastard. But I think IP is a harder subject in some ways than others, because it's so often multi-point. Deciding which points to take and what not to take is a critical part of the game. What bit of prior art? How many do you run? And you don't have that. If it's a contract case, it's a question of construction of the contract. That's it.
Would you say there are any cases on sort of substantive IP law that come close in importance to the ones on procedure that you've mentioned, or is it really all on the procedural side that there have been these innovations?
No, substantive patent law can be really important. I mean, the chain of cases from Catnick through to the disastrous activists shows how important it can be.
You call activists disastrous. Why so?
Because nobody.
I mean, I can't possibly comment given my involvement in that.
Well, your fault.
It's not my fault.
It is. Well, the reason is because nobody.
I think Lord Newberger might be attending this seminar. Perhaps he's going to write in with some questions about that.
Cringing in shame if he is. Nobody knows what the hell the rules are. They seem to think they were following what the Continentals did. Well, they didn't seem to grasp that all the Continentals do different things in different countries. They certainly weren't doing what the Germans do. They went obiter about whether you should patent later inventive ideas, which are equivalents. Not a moment of consideration of policy. It'll die. I regard the whole of the doctrine of equivalence as a sign that patent law hasn't quite grown up yet around the world.
There are some who would say, just looking at it the other way round, that actually it's just the return of a traditional doctrine of patent law. In fact, Lord Justice Burse made a reference to that in a telecoms case recently, of the return of the doctrine of equivalence. Well, I mean, after a period of unhappy absence.
No,
what do you say to that kind of line?
No, I don't think much of that line. But there's always been, well, we'll regard that as inessential or something like that. And that may be done as a matter of construction, which is what Diplock said. It's all a question of construction. But if you want to see a classic version of the Hoffman line, but 100 years earlier, it's in Nobel and Anderson. It's all a question of construction, said the master of the rolls. It's beautiful.
Do you think this dichotomy between certainty and generality of protection is ever going to be firmly resolved, or are we just going to go backwards and forwards with phases of greater attention to the language and then phases of less attention to the language, and we'll just have another phase where there'll be at TARVIS 2 or its equivalent down the line, and it'll all be narrowed?
It's entirely possible, Daniel. I don't know. You can't. I just regard it as somewhat immature to say, well, I think these chaps ought to infringe, so I'm going to hold they infringe. I know the patentee put his claim narrower, but he, you can no longer say we didn't really mean that bit. You've got to say, well, I don't care. I'm just going to give it to him. The Americans did it in Graver Tank, and it was a terrible mistake, and it's led to chaos in America. And what's more, it was due to procedural defects in American law, which people don't appreciate. The patent actually mentioned what the defendant was doing.
But some of the Americans perhaps attending would say, well, at least in American law, there are various other aspects of a doctrine of equivalence which keep it narrow, whether it be file wrapper, estoppel, or others, which we don't have here. It's
all a bit like I was thinking of a plan to dye one's whiskers green, and then also larger fan, they could not be seen. I mean, you have a big doctrine and you have to cut it down.
Let me come back a little bit to your professional career and your decision to become a judge. Was that a difficult decision?
Not really. Actually, I didn't quite realize it was coming. I'd been asked to be a deputy High Court judge, and I'd signed up for that. And I was doing a ridiculous case about nappies. I was leading Chris Floyd and Richard Arnold. And it went on for weeks and weeks and weeks. Ridiculously, the case lasted that long. But it's such an easy subject matter. And I got a message from the Vice Chancellor. He was called the Vice Chancellor then, I think, Donald Nichols. But I go and see him. So I went to see him after court, still wearing my court little jacket. And he said, Robin, I don't know whether you have any ambitions, and I'm not going to ask. But if you do, I see you've been appointed a deputy High Court judge for 3 years and you haven't sat once. Well, it was very difficult, you know, it was a lot of work. Well, I'm just telling you that, he said. So I went and did a week. Actually, I did 2 days because they didn't have any work for the last 3. And then I got another letter, a letter from the Lord Chancellor's private secretary saying, dear Robin, as you know, from time to time, I like to see senior members of the bar. Perhaps you'd be good enough to ask your clerk to make arrangements for you to come to see for tea. So I went, and I had something to talk about. I wanted to say, you've got to do something about this county court judge, because he's seriously hopeless. He wasn't interested in that at all. He wanted to know. And it was put so delicately, so English. If you were offered, would you accept? If the Lord Chancellor were to offer you, would you accept?
And what exactly did you say in response to that delicate question?
Well, I had vaguely thought, but I really hadn't thought about it much. I said, yes, I'll do it. Yeah, I thought it needed doing. It was, if it wasn't me, it might have been somebody else, and that wouldn't have been good for the law.
So I think I was in court against you when the appointment was publicly announced. And how was it announced? At least I thought.
I don't remember. It was meant to be published on the Downing Street website, and they forgot.
No. It was announced in a much more prominent way by Wendy.
Oh, did she?
Turning up to court and sitting in the public gallery.
Oh, I see. You worked it out from there.
I thought, he's going. Because she's just got to want to see a little bit of Robin in his last case.
Yeah, she came with the boys.
True?
Yeah, true. That's the only time you've ever appeared in court with green ink in your nose.
Oh yeah, that was a fabulous moment. Well, not necessarily fabulous for me. Actually, on that case, that was a tremendous case. It was also very striking for your cross-examination. I remember a bit of it where you were cross-examining some technical witness, and you said, who hadn't come up with the invention, and you said something like, "I bet you could have kicked yourself."
Yeah.
I thought, my God, there is a master of the forensic art. He said, "Yes, of course."
Well, he pissed it. I don't know why they called him. I was your call a chap and say, well, I didn't manage to do it. It wasn't. I think very impressive evidence, really.
No, that's quite right.
It's not a hopeless case. I mean, from the point of view of saying it was obvious. I mean, it's got the Nobel Prize this year.
No, we saw that. Yes, it was a tough brief for our side.
I wanted to how many patents have got the Nobel Prize. There was the Ono Institute patent that got a Nobel Prize for the first immunotherapy. I thought it'd be an interesting exercise for some young academic to go over and see what else got a Nobel Prize.
Yeah, and in particular the ones that didn't, that weren't upheld, but nonetheless got a Nobel Prize.
Yeah, well, that would be really, if there are any.
If there are any. So just sticking with Wendy for a moment, of course, everyone wants to know how much influence she has had on your career and indeed on your decisions.
Well, she just
tell us a little bit about that.
Nothing rules. I've got to be very careful.
No, I know.
Well, she produced an amazing sort of family background, which was and is wonderful. We had a fantastic birthday party on Saturday with all the grandchildren. I don't know that she used to get cross with me working, and that's the trouble. When we got married, Nigel Bridge, who came to the wedding, said to her, "You know, baritons are always complaining. They've either got too much or too little." You know that too.
And on working, you have this reputation of doing things very easily. How much paddling has there been beneath the surface?
Quite a lot, actually. Quite a lot of worrying about the fact that I hadn't read the papers. But somehow I hadn't got the patience to get into them all in detail. But I was quite a last minute man. You know, I'd go in the night before in Chiron against you. I was in till midnight the night before I cross-examined that bloke and everyone else I cross-examined. But it's in your head then.
But tell us a little bit about first instance judging and how it compared with your later experience in the Court of Appeal. I mean, you like being in charge of things and the development of the law. Did you feel you actually had more autonomy in a way as a first instance judge than you did in the Court of Appeal, or not really?
No, not really. They're just different jobs. I mean, I've loved every job I ever did, from being a junior to what I'm doing now. I like being a laundry delivery boy. It was my first.
And memorable cases, either at first instance or on appeal, things that you think really made a difference in the law?
I mean, my first job in the Court of Appeal, I found myself in a split court. And it was a case called Limwhaler. And this was a chap, the Labour government passed some disgraceful legislation, Plunkett had passed it, saying, well, asylum seekers can't have any public support if they don't apply for asylum within 2 days of arrival, unless it's contrary to the Human Rights Act. And this poor chap couldn't read English. There was no evidence that he could be supported by the charity. All the charities said we're full up. They've been. And I said, well, you know, that's pretty important. So I wrote a little agreement with Robert Carnworth. That sticks in my mind. I don't know. It's
interesting because you mentioned a case that's not in the field of IP, and were there other areas of law other than IP where you thought, actually, really, I ought to get myself involved in those, if possible, and if time permitted, that needed a good shake-up?
Well, I did quite a lot of insolvency. I like to think the insolvency bar quite like me. And don't forget, when I went on circuit, I only did 2 IP cases, each of only 2 days, for 4 years. Nobody noticed. They still thought of me as the patent judge, but I wasn't there.
And how did you enjoy life on circuit? Was that fun too?
Terrific. I did no work of any kind for 4 years. I had 3 circuits and London, so nobody knew where I was, or what was going on. And you couldn't get. I mean, in London, if a case settles, the listing officer is trying to shove another one in front of your nose before you move. But if you're in Birmingham, A, you may not tell them. B, if you are, you can't do anything.
So here's another question from one of the audience. Are there any judgments that you've made, particularly in the field of IP, that if you could turn the clock back, you'd change?
Well, I've been reversed twice in the House of Laws on IP, and I think I've gotten both wrong. Most times, of course, they get it wrong, but I do think I got was it Connor and Angie? No, what's it called?
Yeah, it might have been Connor.
Connor, well, I was reversed by Lenny Hoffman. He was right, and I was wrong. And the one about ownership.
Syntax. No, that didn't go all the way, did it?
Syntax, yes, it did. Yes, I was upheld there.
Yeah.
I got upheld more in non-IP than in IP, actually.
And on that subject, sitting with judges who are not specialists in IP, I remember one occasion appearing in front of you in a case about disclosure in obviousness cases, where unfortunately you were put into a minority. Actually, I remember a party after that where we met, and I thought I feared for my life seeing you after that.
I'm hopping mad about that one. It was all about discovery.
It was.
It was all about discovery being disproportionate.
And you were basically trying to bin a disclosure in obviousness cases, and you weren't allowed to do so by your colleagues in the Court of Appeal.
Yeah, and there's not a good. Most people think I was right. If they put an affidavit, if the other side had put an affidavit or whatever it's called these days in, saying it's going to cost so much, which is more than what the case is worth, that would have changed it. But I could work that out myself, but they couldn't.
So I think probably Lord Justice Burse fixed that in a later case called Positec.
Oh, did he? Good.
So you were ultimately vindicated when the rules became a little bit more flexible.
Yeah, well, it was a really stupid. I mean, you were just doing it to bugger up the case, because you knew they were Japanese, everything had to be translated. It was going to be an absolute fortune to do the discovery.
Actually, I tell you, on fun, that was enormous fun, because the prospect of putting you in a minority, which I thought we might just about do, was, I mean, that was like a bar to reach for, even though I knew it would annoy you.
Well, one member of that court I wouldn't sit with when I left the bench. When I came back, and it was one of my rules.
So another thing about the Court of Appeal and appearing in front of you, I always used to remember before court started, instead of the sort of silence that you get before the door opens and the judges come in, there was quite frequently a sound of totally uproarious laughter from behind the door, as though sort of people were in a club and drinking and so forth. And then the door opened and everyone would try to be serious. Tell me a little bit about the relations you had with the fun judges in the Court of Appeal.
Well, I suppose there were various members of the court. Alan Ward, of course, was the funniest case of the lot. One moment, Alan, somebody was submitting, I think Watson was submitting, or no, or maybe it might be Simon Thorley. Anyway, I think it was Simon Thorley trying to attack an obviousness decision, and that's right. And then Watson got up and he said, "All my learned friend is doing is sitting by the canal bank, throwing in a few fat worms, hoping that a judicial carp will take the bait." And Alan turned to Colin on the other side and said, "He's talking about you."
On that subject of the light touch, you you're renowned the world over for your style, brevity, wit. Another famous judge, Learned Hand, who I know is one of your judicial heroes, he said the language of the law must not be foreign to the ears of those who are to obey it. How important do you think the issue is of style in writing?
Well, I think a lot of things about judgment. First of all, I think I deplore the modern tendency for lots and lots of pages. Nenny Hoffman once said nobody should quote any other judgment more than 2 sentences. No judgment should be cited unless it's essential. And if you've got more than 10, there's something going wrong. And you've got to keep it short. It's not a question of every detail mattering. You've got to. My rule was when I wrote the first draft, I then went over it and over it and over it, deleting stuff.
Well, on the subject of judgments, which are not always short, but also not noted for style, European court judgments. You've had something to say about those over the years. And I'm just going to remind you of something you said, for example, about the L'Oreal judgment of the Court of Justice some years ago, where you said, my duty is to follow it, but with great regret. Because in that case, I think you took the view that that the law was a muzzle on freedom of speech, or potentially
competition.
What do you see as the way that the law should develop now outside the EU and not constrained by the CJEU? Do you think that there is a real opportunity to depart from the approaches that the CJEU has taken in IP law, and if so, in what areas?
Well, I think that probably will happen. And we've had Brexit. I think we're now on our 9th Brexit from the time that Doggerland was flooded. Some of them have been new exits, like when the Romans went. And it's an island nation. And I think we are a bit more competitive and less droit senior attitude towards IP and everything else. And I think we may become more competitive. It's not so easy now because, frankly, the world's economy is one economy, whether you like it or not. But I think we'll have to see how it goes. I mean, I would hope that someday our courts will depart from L'Oreal.
I mean, some might say, well, actually, the Court of Justice did depart from it, or it modified the law so it was a bit more realistic in later cases. Are there other areas where you think that the European approach is pinching too much? For example, supplementary protection certificates, the approach to originality and copyright, and so forth. Or is it better to try and follow the pack? Well,
I think let's start. I mean, they're different things. SPCs. I mean, that was a disaster waiting to happen. It's not the court's fault. They've made it worse. But frankly, it was drafted by some people who said, "Oh, this is terribly easy." And it's actually in the preparatory documents saying this is very easy to be administered by national patent offices, and there'll be no difficulty whatever. And that was written by people who knew nothing about A, patents, or B, regulatory systems. And they're finding it very difficult to do anything about it. And it's developed in a very unsatisfactory way because it's not recognizing innovation. I mean, if you take Nurim, which I gather people now think was wrongly decided, there's something fantastic if it's wrongly decided. It was a new medicine. It had to come to market all the way. For all practical purposes, the fact that it had been put in pills to stick behind the ears of pregnant ewes didn't really help you very much medically.
So you seem to be suggesting that there might be some opportunities here to make new law in the UK, or at least take a lead on making law, which may then have a repercussive effect on law in the EU now that we're out of it. Do you think that's likely?
Now, if I was the UK, I would abolish SPCs altogether and go back to patent term extension. So I grew up with a much better system. You just run the patent on, depending on how much money they've made.
And other areas where you think on a legislative basis that there are innovations that can be made in the law that are enabled now by being out of the EU?
Not so much, I don't think. I mean, copyright it's been affected to some extent. How much we still don't know, because our courts have yet to decide. I mean, whether it's actually an open-ended, is it artistic without being any kind of particular work? I know it's been decided by Judge Haycon, but whether that's really going to be the law at the top, I doubt. I don't know. One might say, well, if you're going to make that sort of decision, you really ought to make it directly. For it just to come, it's not even a European legislative decision; it's a European Court of Justice decision. That it's all open-ended. I don't know that the legal systems where you say it's open-ended and the perfume can be a copyright work or cake. I'm not convinced of that at all. I mean, if you think it's not really policy driven, it's driven by a different policy. What we want to do is to encourage things that need encouraging.
So do you think that there are too many questions that are left open by the legislature, which are then put on the sort of too difficult pile for them to deal with, which then come to court, and then the court is blamed, whichever court it is, for filling in gaps that really ought to have been filled in the legislation in the first place?
Sometimes that's true. I think that is true sometimes.
We've got a lot of legislation by recital in EU directives, which is probably problematic for courts making decisions.
Yes. I mean, looking at the sort of legislation, the international legislation, undoubtedly the European Patent Convention is a very high-class piece of work. But then a lot of care went into it.
On these harmonization issues and on the EPC, prospects of the UPC, before or after your 90th birthday?
Well, I think it's probably got enough behind it now to make it happen. But how well it will work, I don't know, because the vision was that the common lawyers would be there too.
Can it really be as good without the common lawyers?
No. I'm sure my continental friends were saying arrogant sod, but it won't. Peter Meyerbeck once put it a different way. He said it won't be so much fun.
Some of the continental lawyers might say, well, it's an advantage not having all of those Brits messing things up with lots of expert evidence and making things much more complicated. And if you just leave it to the court to decide in a EPC kind of way, everything becomes much more streamlined. What do you say to that, leaving aside the fun?
Well, I think we're more likely to get it right by our system than theirs, that's all. And if the case warrants, if the money's involved, if it's not, then I do it that way. But don't think that all cases are the same importance, because they're not. And
one of the things that you've been very much involved in is harmonization by fun, if I can put it like this, or at least by lunch, arranging these judges' conferences or being behind them. Do you think that the very fact of getting the judiciary together in all of these sessions has actually created more harmonization than even the sort of legislative processes have, just because people exchange views, they're able to discuss things in an open way and find out that the differences are not quite as great as they may at first appear?
I think to some extent that's true. I mean, it was put once by Judge Steinacker when he said at the Madrid conference, I think in 1997, that somebody once used to hand him and say, here is an English judgment. And I used to say, thank you very much, and put it over to one side. He said, now I read it.
That's progress.
That was progress. I do wish the German judgments use shorter sentences.
On foreign judgments and courts, of course, there's a big issue, FRAND and SEPs, which has given rise to an even bigger issue about disputes between courts.
Yes.
I know you've spoken about. How do you see all of that developing? Because we've now got courts that are asserting their powers in countries where previously that hasn't really been done quite so much. There's a much more open legal landscape than there was even probably 15 years ago. Where do you see all of that heading? Conflict or?
Well, I mean, nobody can see a way out of this anti-suit, anti-suits injunction situation. And nobody's actually enforced it or can run contempt proceedings or anything. I don't know what happens if you pay no attention to it. But frankly, if you think about it, this is a world licensing situation. What you need is a world body, not a national court, which even if it gives a perfectly fair thing, won't be thought to be fair.
A lot of people have asked questions about arbitration and how you see that developing as an alternative to court procedures in some IP. Do you think there's a bigger future for that, or not really?
I think there is. I mean, the Japanese have set up a whole centre for it, well organised with judges from many countries. I actually think that probably it'll be more acceptable if you have an international panel of arbitrators than if you have a judge or a court from one country. I note that some companies offer arbitration. Nokia does, and Sysfel do, and probably some others. But then the other side said, no, I don't want arbitration. You know, start asking yourself why. The answer,
so I've got quite a lot of questions in of a general nature about developments in IP law, what you would like to see if you could wave a magic wand and implement developments over the next few years. Are there specifics that bug you?
Well, I think the world would be a better place if the Americans didn't have jury trial for patents.
It's quite a tall order, might involve some constitutional changes.
Yes. I mean, that's the trouble. I mean, they can't change their constitution. It's a long time since they did. Maybe they could have a vote about this.
And on the academic front, educational front, are there things that you think need to be done about legal education from your now long career as an academic as well as a lawyer and judge? And what advice would you give to the class that you've just been involved in teaching?
Well, I'd like to talk about this year's class. This year's class is both the LLMs and the LLBs. They've been brilliant. I mean, to be doing what they've done, they may be the best year I've seen of the 10 years I've been at UCL. Some of them are just quite astonishing, and they've kept going. Some of them in China, some of them in Romania, and we're all over the place. Fantastic.
And presumably you'd advise all of them to stick with IP.
No, I don't. I mean, some of them they're doing all sorts of other things, but they may make a lot more money in international arbitration or something. But some of them do, and of course I'm very proud of my very first Moot team, both of whom are members of the English Patent Bar, one in your chambers and 111 South Square.
So I'm also getting lots of questions asking you this. If you had the chance to choose just one of the professions that you've been involved in, advocate, judge, or academic, what would you choose?
Advocate. Although I'd like to be younger too, because litigation is a young man's game or a young woman's game. That's the most exciting. It has the biggest highs and the biggest lows.
Well, Robin, we are all very, very glad that you've done all of these things and made such a huge contribution in those areas. It only remains for me to thank you for that contribution, being willing to share your thoughts with us today, and to wish you a very happy birthday. I'm going to hand over to Matt Fisher, who's introducing a little surprise.
It's my job now to move things in a slightly different direction, and so it's my great pleasure. On behalf of the team at UCL, your friends, colleagues, contemporaries, and comrades from the IP world, to move us on to the second part of tonight's proceedings. With luck, the veils of secrecy have kept this sufficiently shrouded so that it does remain something of a surprise. And so, without further ado, here, as they used to say in the Blue Peter of my youth, is something we made earlier.
As Monty Python might have asked in The Life of Brian, what has Robin Jacob ever done for us? Well, he's had a 50-year career in intellectual property law. Started in the 1960s when it wasn't trendy. Okay, so apart from the 50-year career in intellectual property law, what has Robin Jacob ever done for us? Well, he was the best QC at the patent bar for an indecent number of years, and definitely the best cross-examiner. I saw him cross-examine in the Sony Walkman case, the expert in that case, and that was well worth seeing as a young barrister, I can tell you. He was part of the revolution in the Patents Court in the 1990s, when he became a judge in 1992. Was instrumental in the streamlining of patent trials that we now take for granted today. We've all forgotten what it was like before that. He made an incredible contribution in the Court of Appeal with his down-to-earth and realistic approach to the law. And then he had a fourth career, or was it even a fifth career, as a professor at UCL, at IBIL, bringing on legions of students and inspiring them.
I've been asked to say a few words on behalf of the academic community. And the words that I'd really like to say are thank you. Thank you, first of all, for your contribution to intellectual property. Your judgments have left an indelible mark on the field. No law student, no IP law student can leave university successfully without a knowledge of the Pozzoli or Eritol questions. Your judgments have provided a huge number of gems to lighten our intellectual property lectures. You've asked us to imagine a document written in Sanskrit, misfiled in a public library in Alice Springs. You have told us that unused trademarks are abandoned vessels on the shipping lanes of trade. And you have told us that consumers do not expect to eat trademarks or parts of them. Most entertainingly, perhaps, although not always with the approval of your judicial colleagues, you have described the person skilled in the art famously as a nerd. Thank you also, Sir Robin, for your support and encouragement of academic endeavour over the decades. You have offered amazing insights and help to the work we have been doing, so thank you. Third, thank you for your accessibility and openness to academics. It has been a privilege for all of us to be able to talk informally to the leading IP practitioner of their generation and leading IP judge. You have enriched intellectual property scholarship enormously just through being accessible in that way.
I'm here for SIPMAR and for all our members. Every one of us, every day, makes decisions along thought lines which have been shaped by you. Treat, 1-800-Flowers, L'Oreal and Berlieur, and many, many more. All of them setting out clearly how things are, or how they ought to be, all of them written by you. You've written the book, quite literally, and my 16th edition of Curly here has an introduction from you. And most of all, you've always expressed such interest, enthusiasm, and fun. Every chartered trademark attorney stands always in your shadow, and it is a very jolly place to be.
Trying to describe Robin Jacobs' contribution to intellectual property in the world is like that famous line, "How do I love thee, let me count the ways." Robin's strengths, and there are many, include the fact that he's endlessly inquisitive, totally passionate about intellectual property and people, relentlessly intelligent, and able to explain things in a way that makes his view the only one that makes sense. Together with that, he's brought people together from all over the world and welded us from all over the world and all the different countries into a single unit of IP-loving judges and ex-judges, and indeed lawyers of all persuasions, to join together in adopting the Robin Jacob view of world IP. But Robin's abilities in simplifying the most complex concepts and in always thinking up new arguments and new analyses are what makes his contribution to intellectual property in the world unique.
80 not out. I still can't quite get my head around it, Robin. You still seem to have more energy and passion about intellectual property than anyone else in the room. In fact, you seem to have more passion and energy about almost any topic than anyone else in the room. But that's why we all love you. Matt and Alana have asked me to speak on behalf of the academic community about your contribution to international IP. That contribution has been made both as one of the leading IP judges anywhere in the world over the last 30 years and as an academic since moving to IBIL. But there's some things that typify your contribution regardless of the capacity in which you made it. You were always clear and direct. You're always memorable, always entertaining. You're always extremely influential. Of course, you weren't always right, but that's why being an academic was the perfect next stage of your career. You've continued as an academic to make similar contributions. Under your leadership, IBIL has engaged with the leading academic questions in our field and has done so in dialogue with academics from all over the world who've been drawn to the Institute and its activities by your personality and by your reputation. And when I say you have an international reputation, I mean it. It doesn't matter where in the world students learn IP these days, they are reading judgments by Robin Jacob. And that includes places that don't even exist. You contributed mightily to the formation of an international community of young IP students with your time spent on the bench of the Erewhonese Supreme Court, the fictional court of the annual Oxford International IP Moot Court competition. And to all of this, you have brought a truly cosmopolitan disposition. I was always amused at the early Fordham conferences that certain provocative moderators would try and cast you and Hugh Laddie as resistance fighters against European or international influences. That was always good for stirring up discussion, I suppose. But it utterly misunderstood your clear-eyed view of the importance of European norms and international thinking. And your relationship with foreign judges and with foreign academics speaks loudly to your international mindset.
Hi, Robin. No, this isn't a birthday message on behalf of the Arsenal Supporters Club. It's a message from the IPLA, which I am sure is as close to your heart as the Gunners. I can hardly believe that you're 80, given the infectious energy and enthusiasm that you bring to the IP community. Obviously, you've been involved in so many landmark cases, both as a judge and an advocate, that it's been difficult to pick a highlight. However, as you know, one of IPLA's objectives is to lobby for changes to improve IP litigation in the UK. And in Nitya against Argos, you did our job for us. Everyone who read your judgment knew that you were right, and ultimately that was the blueprint for further changes and further judgments which have improved IP litigation. Of course, that is just one example of how you have used your platform to ultimately force a change for good, and for that we salute you. In addition to being a phenomenal IP lawyer, you're also one of our great characters. You're engaging, interesting, witty, and you're incredibly supportive of IPLA and for several individuals. I hope you will accept our gratitude for your encouragement over the years. Finally, although you're the busiest 80-year-old that I know, I hope you're going to find some time in your diary to do a second edition of this book.
Having been told by Sir Robin for 2 years now, I can say that he's a uniquely special person who we've been lucky enough to call our teacher. What I really love about Sir Robin's way of teaching IP is that he crosses this ever-important line between teaching and inspiring. Whatever question you ask him in our classes, you can be sure that he will give you an answer which is soaked in his passion. So a question on the famous Arsenal Football Club case will gain you the perspective of a true football fan. I love that he always speaks about IP issues with joy and vigour, which really evidence his love for the subject. And getting to experience that as one of his students has the wonderful effect that a person's passion always has on those around them. It inspires.
On behalf of the entire IPCAT team, happy 80th birthday, Robin, on this World IP Day. Before I was an IPCAT, Many, many years ago, I was an LLM student specializing in intellectual property at UCL. And it was the first year of IBIL, and it was the first year of Sir Hugh Laddie leading the charge. And I, like all of my colleagues, were just so excited by the passion and insight that we were able to benefit from Sir Hugh and all of the guest speakers and lecturers that came in from the bar, from the bench, from all over the world to teach us about IP. And it has been such an honor and privilege to see you, Robin, with your characteristic energy and gumption and passion for IP, take the legacy that Hugh created and continue that for the next generation of IP lawyers. So on this, your 80th birthday, we wanted to give you a gift of thanks for doing so much for helping to shape the IP profession.
As most people will know, there's an enormous amount to say about Sir Robin, and particularly an enormous amount of very good things to say about Sir Robin. But I first actually met Robin when I went to his chambers to meet Sir Michael Fyshe. And Robin was both enormously encouraging to a young or new person at the bar, and also very enthusiastic about finding somebody interested in intellectual property. And before I left, he did something that to me epitomizes him. He gave me the very recent edition of Laddie, Prescott and Vittoria, with an encouraging and personal and very humorous note in the front of it, which often made me laugh when I had to refer to it, even after many occasions. And I actually kept the book. It meant so much to me. I'd like to say something in my mother tongue for the future for Robin. And it's a very short little expression, and it is Ganairi an Boherlat. And this translates into English as "May the road rise with you." It's a greeting that we give to people when they set out on journeys, so that their journey will be easier than it might otherwise have been. But I offer it to Robin in order to ensure, I hope, that we see another 20 years of Robin with all these same enthusiastic way of living, with the same wonderful sense of humor, with the same enormous respect for all those people that have crossed his path over the years. And I very much hope that I will have the great good fortune to be part of that next 20 years, or perhaps even more than 20 years.
I'm honoured and grateful for this opportunity to say a few words on the auspicious occasion of Sir Robin's 80th birthday. And of course, I'm speaking in a personal capacity here. I first met Sir Robin back in the late 90s in my initial years at the OHIM, as it then was. And he came to our office with Geoffrey Hobbs to the annual meeting of judges. And this formidable UK team explained to the audience of fellow national judges and OHIM staff about, firstly, the treat judgment. And there was quite some explanation about the nuances of the word treat in the English language. And Sir Robin immediately showed his very practical approach to trademarks, and saying that actually what happens on the register doesn't tell you what's happening on the market. And this was a real call to reality for us rather hypothetical and theoretical people at OHIM involved in our world of battles on the register. And remember, this was at the beginning of EU trademark law. We had no decisions from the General Court, few decisions from the boards of appeal, and just a handful of judgments from the Court of Justice.
I'm sure lots of people have said lots of wonderful things about your amazing contribution to IP. So I'll just add to that you're definitely the biggest name in IP in the world. Your reach goes way past Europe to the US, to China, to Kazakhstan. You're also, of course, the most quotable judge. Congratulations on a fantastic contribution from that perspective. On behalf of patent attorneys everywhere, you've long been a champion of what we do. You big us up to people and talk about what a great job we're doing. It's lovely to hear that. You've always been a keen supporter of our contribution to litigation, and you know a good claim when you see one. So thank you for that as well. And you've also been a supporter of the profession more broadly. SEPA's loved having you on our podcasts. And let's not forget that I think you were the head judge in SEPA's first ever Battle of the Bands, which is a fantastic night a few years ago now. Hopefully we'll get back to those soon. On a personal note, I'm really, really proud to count you amongst my friends. I can't believe that you're still willing to cycle to the pub for a curry and a pint and a bag of crisps, but I really hope that we'll be able to do that soon.
You've done so much over the years for the world of IP, and I mean the world. For me, it's a moment to reminisce about all the fun that we've had over the years. First, there were the two likely lads from Coventry who wanted to stop the great Chelsea man chain from opening a nationwide chain of stores. I've managed to fail to get an interim injunction, but as you pointed out when you were brought on board, that can be bad news for a defendant. And so it proved as we shipped busloads of witnesses into court to prove that our reputation in Chelsea man had been virtually wiped out by the defendants. Next, there was a case about copyright in wallpapers that you may recall, where our solicitors had said to the client that if we lost the case, he'd take up pig farming. Each day, the client thoughtfully brought to court a pair of Wellington boots, which he placed in full view of the entire team to remind us of the promise that had been made. Again, you pulled off a win, and we are not slopping out the styes, but enjoying, at least in my case, a happy retirement. The amazing thing is that you've had two great careers since then, as a judge and also as a professor, and you've not finished your contribution to the art by a long way. I'm sure there's lots more fun to be had in the future. I've enjoyed our trips together to Shanghai, to Washington, to Tokyo, to New York, and of course to Venice. Let's hope we meet many times and continue to have such fun.
Okay, well, apart from all else, what has Robin Jacob ever done for us? Well, in all of this, he's kept his same youthful enthusiasm that he's always had. And you can't beat that. Thank you, Robin.
So, happy birthday, Robin. And as it says on your coat of arms, L'chaim.
Have a great day and carry on.
So on behalf of the IP Cat, as a UCL alum, and as myself, happy birthday, Robin.
Have a fantastic birthday, and we'll be catching up at some point.
Very many happy returns of the day, and I hope very much that we will soon be able to meet again in person.
I hope that when we get past the COVID crisis, we will renew acquaintance in person at any number of international venues. But in the meantime, enjoy your birthday.
Happy birthday, Grandad. We love you lots. We've been really missing you over lockdown. We can't wait to see you more now that you've been vaccinated. Bye. Bye.
And Robin, darling, many happy returns, happy birthday, and my only sorrow is that I'm doing this remotely and not in person.
What more to say to Jacob J on International IP Day than 80 is a splendid way to celebrate this year. a judge in UCL, a birthday boy today as well. All in all, it tends to spell spectacular career.
Oh,
you
right.
are. A cake and a very large Magnum champagne.
Oh, God.
So I'm not quite sure where to put it down. We can put it on the top. Can we put it up here?
So a brief explanation for those who are not familiar. The cake could only be an infringing copy, a Viennetta,
Viennetta,
with a Lego judge on top. And it comes from all at 8 New Square with our gratitude, love, and affection. The champagne, of course, has got to be Bollinger. Happy drinking. And with that, I have great pleasure in handing over to Mr. Justice Mead, the newest judge in charge of the IP Court, to offer you a toast.
Can I say how much I've enjoyed the last hour? Thank you to Daniel. Thank you for everybody who did that magnificent film. I fear I'm only going to repeat what people have said already, so I shall move along swiftly. I must add my personal thanks to Robin. I've known him for 30 years. I'm one of, I think, probably literally hundreds, maybe thousands of people who are in IP because of Robin, and in my case in 8 New Square, and I did early cases with Robin, which were a revelation and an education, shall we say. If I can just add one story, I remember very early on with Robin doing a case quite late at night in Francis Taylor Building. We were burrowing through some case law, and Robin said to me, you know, Richard, cases can seem really, really boring. And he said, what you've got to do is you've got to stop thinking of them, and I think he actually said in an academic sense, which is probably not how you should read it. Don't think of them in an academic sense. Think of them as weapons, think of them as bullets and guns, and then they'll be a lot more interesting. And that certainly kept me going many, many times in my practice. It's World IP Day. It couldn't be a more appropriate day to celebrate Robin's 80th. He's been a dominating figure in UK IP for, as many others have said, over half a century. We couldn't be more fiercely proud of him, but he's an absolutely unique figure in world IP. I really don't think I've met an IP practitioner anywhere in the world, anywhere in my career, who hasn't known who Robin is, who hasn't known his judgments. And I will go so far as to say that even if there are people who think they haven't heard of him, they have, and they're doing things and thinking of things the way they do because of Robin. And there are probably young IP barristers in the UK who don't know that things they do every day are that way because of Robin. The whole way that we organise cross-examination goes back to Robin's development of things he used to call kits at the very beginning of the 1990s. There's nothing you do in IP that isn't influenced by him. It's like Blackpool going all the way through a stick of rock. There's Robin everywhere you look. People have mentioned all the various careers he's had: an advocate, a judge, an academic, an author, a commentator, an arbitrator, a mediator, a participant and promoter at endless talks and conferences. We've been talking about him for a while this afternoon, but I know also he's been a hugely important figure at Gray's Inn, and with Gray's Inn education, not just in IP, but in every aspect of the Inn's life for many, many years. So you can talk all night, and I think you'll still have missed out achievements and accomplishments of Robin. So with all that, Robin, congratulations. It's been a wonderful career. Sir Robin Jacob, Professor Sir Robin Jacob, Professor Sir Robin Jacob QC, the Right Honourable Lord Justice Robin Jacob, Privy Councillor, etc., etc. Cheers and happy birthday.